Brooke Robinson. This is one of the topics that I get asked about the very most. And I feel like, oh, we do this all the time, but protective orders are pretty complicated in Utah. And even looking over their charts and their handouts are provided, it's like, oh yeah, no wonder why we actually need this training. It is so valuable and so complex sometimes. And so we have Tatiana and Brooke, bless their hearts, like scheduled for the next 3 hours. They will build in some breaks into their time. And like I said, this will be recorded, so if you ever need to go back to that. So I'll turn the time over to Brooke and Tatiana. Is ready?
Okay.
Oh, we're gonna start us
We'll
off.
start off and kind of trade off. I'm trying to figure out the best way to look at the screen.
Do you want to put like your laptop here so you can see it?
Okay, let me just situate this a little bit. Bear with me for one moment. Okay. I think if I look at it down here, then I won't be training my neck for 3 hours and getting really sore. So I am Brooke Robinson. Tat and I are here with Timpanogos Legal Center. So we just wanted to talk a little bit about us, just as we get started and the services that we provide. We're kind of a unique organization where we fit into the Utah legal arena. So once we get this up, we can kind of walk through this a little bit. Okay. One second. Also, I apologize in advance if I look like I'm crying. My allergies have been going crazy, so. There we go. So at Timpanogos Legal Center, our mission, we are a nonprofit organization that empowers victims of domestic violence and low-income Utahns to navigate the legal system through innovative and trauma-informed legal services. TLC recruits and trains legal professionals to provide pro bono work in new and meaningful ways, which enables thousands of people each year to pursue or defend their rights in court and ensure stability and security for their families. So we are a small organization, but we serve statewide. So for those of us, or those of you that might think maybe we're just in Utah County, we are statewide. We are primarily remote, but we often go out to shelters and go on location. And so we try to fill in the gaps for parties that might not be able to get full representation in court, because obviously we can't get pro bono attorneys to cover every single case in Utah. There's so much, especially when it comes to domestic violence and victims of crime. There's just more that we wish we could do. So here's some of our staff. You can see we have a lot of staff. We're all statewide. I think when I started 6 years ago, most of us were in Utah County, but I now live up in Ogden and we're all over the state, and we'll kind of walk you through that. So you can see we kind of have different positions in what we do. This is just to familiarize yourselves with us. If you have any questions. Yes.
Sorry, we just got a little bit of technical, or for some reason our screens are not matching our online.
No worries. I'm just surprised that it's not me.
No, it's not you. It's we always blame the equipment. And then one more thing really quickly. Give us just a second. We want to make sure our interpreters were having a hard time understanding. And so we do want to make sure that they can. So as I'm talking, we're just testing this out with them. Thank you, Maddie, for all of your help always. And the interpreters can hear. So, all right, just for this, it's probably keep the microphone close and then talk slower than you think.
Probably step away from the house, like where you're standing.
Right here.
Yeah.
Yeah. Okay.
People need to bring something to bring your laptop closer to you. So this is our camera, and our microphone for the whole online attendees.
Yeah. Okay, sorry, I didn't realize I was standing right next to the microphone. Is this better? Okay, you guys can hear that? Okay, so here's a map. So one thing that we try and do with Timpanogos Legal Center is we are not serving one specific area. Our goal is to serve all of Utah, and so we want to make sure that we get to know the advocates that are in each area, the resources and the clients. And so we've assigned a staff member over each judicial district in Utah, and we try to partner with the different courts, the court clerks, the victim advocates, the shelters, other partner organizations, and we provide lots of updated lists of resources. So if you ever need a handout, you can look at, okay, Tooele County, here's a sheet of resources, including the local food banks, the shelter, legal resources in your area, all of these different things. And so we try to make sure that we are fitting all of the needs in Utah. And so you can see here's a map. If you have questions, or if you're serving a particular district, or if you're an advocate in a particular county or city, if you have questions or want to set up any trainings, or if you need material, just look up here and you can see who's the primary point of contact for your district. Obviously, you can contact any of us, but maybe just start and get to know the person that serves over your district. So for me, I live up in Beaver County, and so I work a lot with the YCC and Safe Harbor. And so we're all trying to get to know the different advocates and shelters. So take a look at this map, and if you have any questions, feel free to reach out, or if you need to look this up, let us know. Okay, so what we do at Timpanogos Legal Center is a little different than maybe some other organizations you might be more familiar with, like Utah Legal Services or Legal Aid Society, where they take regular cases start to finish. We try to fill in those gaps, and so we are here to help self-represented parties that don't have an attorney. We try to help our clients in small pieces along the way. Maybe they need help with a particular document, or maybe they just need some advice to get to the next step. Or maybe they just need some help figuring out what they need to file, or resources of where they need to go. And so we figured out that we can serve a lot more clients in smaller chunks, rather than just taking a handful of clients and helping them with their case start to finish. And so this is a way to try and expand services and have a broader reach for our clients statewide. And so some of the different services that we provide, we have a free legal hotline that we staff Monday through Friday, 9 a.m. to 2 p.m. And so this is really nice, because unlike maybe some other places where you might have to do like screening first or an intake just to get through on the phone to one, we have our attorneys staff that, and we can give brief advice or screen for other services, or set you up for clinic appointments. We also have several Spanish-speaking attorneys, so we'll try and make sure that we get clients in touch with someone that speaks Spanish if that's needed. Just know that we are very busy. I think we've grown a lot in the past few years. Sometimes clients might call while we're on the other line. Just make sure they know if they leave us a voicemail, we're going to call them right back, and we will get back to them. And so just part of that, make sure that they leave us a message. And we also want to know that it's a safe number, so they can mention that. So if you have any clients that say, hey, I tried calling them 10 times and didn't get through, often it's because they call 10 times within 2 minutes, and we might be talking to someone else and miss that call. So as long as they leave a message, we'll get back to them. And so it's really nice just to be able to have an on-call resource for like a quick question if someone just needs to know, what's my deadline, or where do I need to file this, or where's this phone number that I need to get. We can't answer every question as it relates to cases, but we try our best and get the resources that are needed. At Timpanogos Legal Center, we primarily help with family law issues, domestic violence issues as it ties to protective orders, stopping injunctions, some housing issues, and a couple other things. So just guardianships. We also have free legal clinics throughout the state. And so we, oh yes, we also have an interpreter service. So if you have other languages or have ASL needs, anything like that, we'll try and make sure that your clients are getting the services that they need. Then, we kind of got known, TLC really started with our Family Justice Center clinic that's done on Tuesday nights down in Provo, and that's how a lot of people know us, is we have a big one-stop shop in Provo on Tuesday nights from 5 to 8 p.m. And we have our volunteer attorneys there, we sometimes have volunteers for housing, we have victim advocates there, and so it's a nice way to get several services in for clients. So instead of driving all around town and trying to arrange childcare and transportation, they can come to our clinic. And that's been a really nice way for them to check a lot of things off their list and get a lot of the advice and resources that they need. And so we really like this model, but as we've grown as an organization and we've expanded statewide, we have also realized that things needed to change a little bit, especially during the pandemic. We started doing an online legal clinic in conjunction with that in person. So if you have clients that are not in Utah County, we will set all of them up for a Zoom appointment. And so we can do that. They just need to either call us or go to our website so we can send the proper paperwork and make sure that we get them the Zoom link ahead of time. And so these are our Tuesday night clinics. And then we also have regional clinics. And so those are where we're trying to expand services to get in person to the different districts. These are, or you can look on our website for when they occur. Some might be quarterly, some might be once a month or twice a month. It really depends on the district and the need. If you are interested in something like this in your district, reach out to your staff with contact and we can kind of look at the options of what's available. We'd love to expand more of our services. We just have to try and find volunteer attorneys as well. So we're happy to try and staff some of these different clinics. And so it's been a great way to build our relationships with our partners statewide. And then another thing that we do through Timpanogos Legal Center is we have a document clinic. And so we've learned that even if clients don't have an attorney to help them start to finish, it's been very helpful to be able to draft certain documents for them, because even if they can't represent themselves well in court, as long as they have well drafted documents, the judge or the commissioner is going to look over those and they're going to read through them. And if they present strong arguments and present what the client looks for in court, this can go a long way. And so this has been something that's really cool. We've been able to get volunteer attorneys or law students that help draft these documents for clients that might not be able to do it themselves. Maybe it's for a motion for temporary orders or alternate service. So a lot of them are in custody and divorce cases. And so it's nice, especially if clients maybe don't have access to a computer and can't draft forms themselves. We'll try and set them up. We'll screen them, see if we can set up an online appointment and help draft some of these documents for our clients. And then another thing we have a lot of different handouts on different topics that might be helpful for you or your advocates or some of your clients that you're working with. We try to keep these updated. We go through them every year and update them with current information, new statutes, new legislation that's passed. So you can see there's different things we have about victims' rights, safety planning, divorce, legal resources, support resources by each district. So you can find all of this information on our website. So these are just some of the many services that we provide through Timpanogos Legal Center. And if you have any questions, we're happy to answer those as we go through our presentation, or if you want to know more about what we do at Timpanogos Legal Center. Okay, so this is an overview of what we'll be covering today. So we'll be talking about our Certified Advocate Partners Program, and then we're going to be going through Utah Protective Orders for most of the presentation. And then we will also be breaking down what's the difference between legal information and legal advice, because that is a big hang up where we want to make sure that we are doing the right thing and not giving legal advice as advocates when we are not supposed to do that under the rules of the state bar, and kind of explaining the difference of what information and legal advice is. So we're going to move along to this part, and we are going to have Haley, one of our colleagues, join us online, and she is going to talk us through the Certified Advocate Partners Program. And so hopefully she is able to connect online, so let's see. Yeah.
Hi, Brooke.
Be patient with this hybrid's always kind of thing, but I'm gonna allow Haley to start it or
Turn this off.
and we possibly may have some microphone feedback.
I can,
Okay. Can you hear me, Michelle? Perfect. Okay. Perfect. Let me pull up the PowerPoint on my end. Okay. So, like Brooke said, I'm Haley Cousin. I'm with Timpanogos Legal Center. I'm one of our staff attorneys, but I'm also the director over our Certified Advocate Partners Program, which is our program in which victim advocates are able to get certified to give legal advice, not just legal information, when it comes to protective orders. So I'm going to talk a little bit about the program, how it came to be, and then also how you can get involved. So this program is considered an access to justice program, which the National Center for Access to Justice defines as when people encounter life challenges, they're able to understand their rights under the law, protect those rights, obtain a fair outcome, and know that the result will be enforced under the law. In our current legal system, a lot of that involves needing an attorney or really needing to know the legal system, your rights, the whole shebang. The Utah courts did a survey a few years ago of all their cases, and they found that over 80% of people who need legal help can't afford it. In 3rd District alone, which is that Salt Lake Summit, Tooele County belt, which is our largest judicial district by population, 93% of people went unrepresented in court. Most of those cases were family law cases, housing cases, and debt collection cases. Obviously, this is a big problem if we want people to be able to assert their rights and get fair outcomes. This isn't working. So our Utah Supreme Court said, what can we do to help this? You know, there really aren't enough attorneys. I know it feels like there's oodles of attorneys, but there aren't enough attorneys to address all the needs that we have. So they came up with what's called a regulatory sandbox. This sandbox, we say we get to go play in it. We get to change the rules of the practice of law. So the big one for our program is we've taken out the unauthorized practice of law rule. So typically you have to be a barred attorney to practice law. And we're saying, nope. Their whole thing in looking at what programs will be allowed into the sandbox is what is the benefit to the consumer, but we say client, versus the risk to the client. If people were to partake of services from this program, are we putting them at a larger risk than if they were to meet with an attorney? So with that in mind, we came up with our program, the Certified Advocate Partners Program, which I just call CAP because it's a mouthful. In our program, our attorneys train and oversee advocates throughout the state in providing legal services as they pertain just to those civil protective orders. So those cohabitant abuse protective orders, stalking injunction, child abuse, sexual violence, dating violence, just those. So this model was really attractive to the court and the innovation committee because it was low cost. We just have to train you. You're already in the areas doing the work. You as advocates are very capable to do this. Once you get that training, you have that real life experience and you're passionate. And that's incredibly important in doing this kind of work. We were able to start offering our services in 2021. So our advocates in our program get to provide legal advice, draft protective order requests, prepare the client for the hearing. So that's kind of the 3 buckets. So the legal advice, which you'll get into a little bit more at the end of this presentation with Brooke and Tat, they're able to say, yes, I think you're going to get this protective order based on what you've told me. They can say, this is the one you actually qualify for. And they can say, don't put any of that. Don't put any of that in the petition. put this information, write it this way. They're able to draft the protective order request using some legal writing strategies we teach them. Typically, advocates are allowed to scribe, so like write down what the client says. Our advocates are able to go off on their own, draft it independently. And then lastly, they can help prepare the client for their hearing, whether it's protective order hearing or a stalking injunction, which involves evaluating evidence. So like we teach them the rules of evidence and all that involves helping them write out testimony, questions, teaching them how to question witnesses if that's going to be a thing in their case, walk through court procedure and talk about court rules. So, and like I said earlier, you will talk a little bit more later today about why that is special versus what regular advocates can do. So we've been offering services for 2 years now. We have trained 13 advocates. They have been able to serve 199 people in this program. They assisted on 153 orders. So those 40 people who didn't get orders assisted usually came to the advocate and said, I want one. And the advocate said, you're probably not going to get it. Let's go a different way. And they were able to channel them into more successful strategies and paths. In getting ex parte orders, 82% of those orders got at least ex parte, which is much higher than the statewide average based on the information the courts gave us. So we know this program is working. We know you're capable, and we're excited to see where it goes. So here is our list of current certified advocates throughout the state. We have them mostly in more rural areas, but we do have a few in more urban areas. If you have questions about the program, I'm sure any of them would be happy to talk to you about their experience. So if you're interested in participating in this program, we will be releasing our application for our next training cohort next week. It will go out in the SWAVO newsletter next week. It will also be on our Facebook page. It will also be on our website. So you can go any of those places, you'll be able to find the application. If you want to participate, there are a few eligibility requirements. This goes back to risk versus benefit, and what the Supreme Court told us we could do with our program. So you must have several years of victim advocacy experience. We are saying you need at least 2. So if you have less than 2, don't apply for the program. We won't be able to accept you. Let's get your experience and get you more trained, and then you can apply for that program when you hit 2 years. It doesn't have to be at the same agency. So if you were somewhere and moved and you still have 2 years combined, that works. You must be an employed victim advocate. So we're not taking volunteer victim advocates right now, and you must assist clients with civil protective orders. We're looking to train around 10 advocates this year, and the training involves about 10-week commitment and about 8 hours every week. We decided to spread it out so that we didn't have to take you completely away from your work for several weeks. Advocates have said this works pretty well. There's reading, there's quizzes, there's live trainings. The schedule will be in the application packet, so you can kind of see what that entails. Advocates are required to report data on their clients to TLC every month. I do want to stress that this is absolutely required for our program. We have to report back to the sandbox and Supreme Court, but we do not report any client identifying information. So advocates don't even report names to me or addresses or anything like that. It will be anonymized. I will have basic details about the case, but you won't be sharing all of that sensitive client information with me or with a third party. And lastly, you do have to have your supervisor consent to apply for the program because it is a big time commitment. And then they also have to sign your contract if you are accepted into the program. So though that is kind of the big picture overview of the program. Are there any questions about what it entails or applying for it or anything like that? I'm going to say no. And that's perfect. If you do have questions, feel free to ask Brooke or Tat today, or you can send me an email and I am happy to talk to you.
Thanks, Haley. So, as I said before, I am Tat or Tatiana Christensen. I work for Timpanogos Legal Center. And just so you know, I am also, we've decided to start, I started working for Timpanogos Legal Center in March of this year. But before that, I had about 12.5 years working at Utah Legal Services, providing direct services to clients for most of that time in divorce, custody, protective orders, drafting injunction cases. And working exclusively with victims. So we need to go through here. Here we go. So today we're going to be talking about Utah protective orders, and we'll be talking about the different types of protective orders, what qualifies a person to get a protective order, and I encourage questions of any kind or comments. So please raise your hand here in person or in the chat, put your questions in the chat, and hopefully we'll be able to discuss that. I love participation and questions, so please feel free to do that. And also please let me know if you can't hear me or if you need me to clarify something, or if I need to like put the microphone closer. We're going to be taking a break at about 10 for the bathroom break for about 5 minutes, and then we'll probably take another one at about 11 o'clock. So just so you know that I'm not going to hold you hostage here. You're not going to hold you hostage here completely until noon. But just let us know if you have any questions while we're talking. So the overview here, as we're talking about protective orders, we're going to talk a little bit about criminal protective orders first. We'll talk about the different types of civil protective orders. And then we're going to talk tips, tricks, experience, questions, all of that good stuff. So let's get started. Okay, for criminal protective orders, there are two major types of protective orders that we have. We have criminal protective orders and civil protective orders. We have some handouts that hopefully Rochelle's been able to provide. She's nodding yes. That kind of talk about the difference between the criminal protective orders and civil protective orders. The major difference between these two is that civil protective orders, a person can fill out a request, a petition to request from the court. The criminal protective orders are imposed by the court automatically, and you don't petition for it. So when someone's arrested for a DV crime, a domestic violence crime, or assault, then they're automatically going to put these criminal protective orders in place. The victim or survivor doesn't really have a lot of say or control over these criminal protective orders. It's really just the criminal system and the criminal judge, which may be a completely different judge, and it's usually a different judge that is handling the civil protective order for the same victim or survivor for the same incident. So these criminal protective orders can have a lot of different names because of the way that they function. So for the jail release agreement, a DV offense is committed. The process is initiated when the perpetrator is arrested, and the jail release order or jail release agreement says that they can't leave the jail until they sign the jail release agreement,
or before the matter is taken before a judge. It expires at the initial appearance in court as the perpetrator is a defendant, or after 30 days, whichever is first. And the case for all of these types of protective orders, these criminal protective orders, it goes away when if the case ever gets dismissed. So it goes poof, it doesn't have life beyond the criminal case. If the criminal case gets dismissed, so does the criminal protective order. Then there's a pretrial protective order after the perpetrator is released from jail. Charges have been filed now, and the defendant makes the first appearance, then the jail release agreement is going to get dismissed, and a pretrial protective order is going to take over usually. This expires when the trial is complete or when the charges are dropped. The case is dismissed. Sentencing protective order for a domestic violence offense happens similarly. It's kind of what you'd expect. Perpetrator commits a domestic violence offense, they are convicted or they plead, make a plea in advance, and then the court will impose this sentencing protective order. If it is a plea in advance, one term of the plea agreement is compliance with the order. And if jail or prison time is part of the sentence, then a continuous order is entered. But if there's no jail or prison, this sentencing protective order will expire at the end of the perpetrator's probation. A permanent criminal stalking injunction is just kind of what it sounds like. It's a stalking injunction for the crime of stalking. If someone's convicted of or pleads in advance to the crime of stalking, there's going to be a permanent criminal stalking injunction in place. And it is permanent until and unless the victim requests that it be dismissed. So with any of those, a lot of times the provisions of the criminal protective order almost always are going to include no contact with between the perpetrator and the victim, that the perpetrator can't contact the victim, that the perpetrator can't go to certain addresses. They're going to be trespassed from certain addresses like the victim's home or school or work. But they're not going to have all of the different provisions that a civil protective order is going to have usually. And again, the victim or survivor is not going to have a lot of control over what happens, what provisions are in the protective order, if it's a criminal protective order, or when it gets dismissed. Any questions about these? Yes. Yeah, Brooke, that's absolutely right. There we go. That's absolutely right. What Brooke just said, they can have both at the same time. There can be a criminal protective order in place and a civil protective order at the same time. And often there may be. A lot of times this is very confusing, this process for a survivor, because they're communicating many times with 2 or 3 different courts. If they've got a case going on in a criminal case going on in one court, then they have their civil protective order going on in another court. They may have, if there's child abuse involved or child custody issues that are going on in the juvenile court, they may be dealing with 3 different courts and several different orders that are all extant at the same time. So it can get very confusing and there could be a lot of questions about that.
One point I want to make is to help, and this may be easy, I'm so sorry. Continuous protective orders aren't just for DV offenses. They're automatic DV offenses when there's time in jail. But if it's a non-DV offense, you can petition the court and all you have to do is prove that there's a reasonable case. And so that's the big thing, when we were in the.
Here, let me let you say that so that I don't have to repeat it here.
One thing to point out is that continuous protective orders are not just for domestic violence cases. They are non-domestic violence cases as well. The burden just shifts to the victim and they have to prove that there is a reasonable fear for their safety. And the reason that's important is we can get those orders in sexual assault cases and child abuse cases and things like that. And that was the biggest compromise we made when we gave up civil protective orders being 10 years. Because the defense bar was unwilling to they were insisting that we had to drop it down lower again. And so the compromise in our work group was making it so that continuous protective orders are automatic in DB, we created a bed, but also applicable to non-DB cases if you petition.
And you can request them at any time. Thank you for making that distinction. I did not know that piece of history there, and that was put in as part of reducing the civil protective orders down from 10 years to 3 years. Very interesting. Okay, any other questions or comments about criminal protective orders before we go on? All right, so moving on. Perfect. I know where that piece is going on. Maybe I can so okay. Is that okay? No. Okay, sorry. Okay. All right, so probably the most common type of civil protective order, as most of you know, is the cohabitant abuse protective order. There are several requirements for filing a cohabitant abuse protective order. And one is that the parties must be cohabitants. The definition of a cohabitant is not necessarily straightforward. It's a legal definition. The parties must be 16 years or older or emancipated. And each party must be or is or was a spouse of the other party, is or was living as if a spouse of the other party, is related by blood or marriage to the other party as the individual's parent, grandparent, sibling, or any other individual related to the individual by consanguinity or affinity to the second degree, and we'll come back and discuss that in a second. Has or had one or more children in common with the other party, is the biological parent of the other party's unborn child, resides or has resided in the same residence as the other party, is or was in a consensual sexual relationship with the other party. And it does not include the relationship of a natural parent, adopted parent, or step parent to a minor, or relationship between natural, adopted, step, or foster siblings who are under 18. So we start asking questions. Let's see. Let's go back to this part of the definition, is related by blood or marriage to the other party. What about, let's see, a niece to an uncle? Are they cohabitants? This is a participation part. Yes. Yes, they are. Does it matter if they never lived together? No, it doesn't matter. They're related by blood. They're with that close of a relationship, they're cohabitants. What about third cousins? Are they considered cohabitants under the statute? No, they're not. See, people shaking their heads. Good. What about second cousins? Still no. What about first cousins? Yes, first cousins would be cohabitants under the statute. What about a daughter-in-law and former father-in-law? So their ex. I see some people shaking their head, but I would argue that yes, that would be considered cohabitant, because you have in the statute is or related by blood or marriage. It used to be is or was. But I don't know, that's one that we might have to look into more to see if their ex-husband, I mean, their ex-father-in-law, they make the argument that if they are still seeing one another and have grandkids that are still involved in each other's lives and have a reason to see each other, might be able to make the argument. Just never know. What about, let's see, what about a person who, let's see, they had children together and the child died. Are those cohabitants? Yes, they are. They would be. Because you have the biological parent, or it has or had one or more children, they come with the other three. Okay, so, yes, question. Okay. I don't have the chart in front of me, so I'm gonna, sorry. Yes, so the question was, someone was looking at the chart of consanguinity. And in the statute, it says the consanguinity or affinity to the second degree is what counts for the statute. And I haven't looked at the chart for a while. So you may be right that a niece and an uncle would be, what would that be, the third degree? Rochelle? Okay, so I'm not an expert in family relations. I was just kind of going off the top of my head, so I could be wrong about that. And thank you for bringing that up. But if you ever have a doubt about whether someone is related to the second, third degree, look up the chart. If you just Google like degrees of consanguinity chart, you'll be able to see that. Rochelle, yes.
Residents are in on a project, sharing the hotel room. Never been before, get in a fight. Are they, you know,
Sharing a motel room, people that are sharing a motel room temporarily, they're migrant workers. Or some kind of workers sharing a motel room, would they be considered cohabitants? What do you guys think? I think so. I would make the argument that yes, because you have lived, that resides or has resided in the same residence as the other party. I don't think it has to be a permanent residence. I think it can be a temporary residence. I once had a case, okay, so let me just ask this question. What about a landlord and a tenant if they live in the same house, like a mother-in-law apartment? You say no? I had a case like that once, and the court considered them cohabitants because they lived in the same residence. So if it's a landlord and a tenant where they don't live in the same residence, the landlord owns the residence and lives somewhere else, then that would be considered a cohabitant. But if it's a landlord and tenant sharing the same residence, I think you can make the argument. Yes.
So if there are other comprehensive and it's not that it will happen, living that.
So the comment was, thank you. I think that's a really good distinction. If it's a landlord and tenant and they live in the same residence and they have shared living space, like a shared living room or shared kitchen or shared entryway or something like that, then that would be considered cohabitants. Otherwise, they may not be. The truth is, it seems pretty straightforward, but in practice, you may have different judges or commissioners looking at this differently. So if there's anything that is a question, feel free to contact TLC and ask us what we think, whether these people would be cohabitants or not. And we'll try to, there's something you could argue one way or another. I think the idea behind having a cohabitant abuse protective order is that these are people that are likely to cross paths often. And so it gives them that special status if they have been cohabitants or are cohabitants to be able to seek this protective order, because they're not just strangers that are unlikely to cross paths in the future. They're people that are likely to cross paths again at some point. So you can definitely make the argument in that way. Any other questions about what constitutes a cohabitant? All right, so that was must be cohabitants is requirement number one. Requirement number two is you must be a victim of abuse or domestic violence. Now, both when I worked at Utah Legal Services and now working at TLC, we talk about abuse and domestic violence a lot, but we have different definitions depending on the context. So I'll give you an example. For Timpanogos Legal Center, in order for us to serve clients at our weekly clinics or through our document clinic, that person, that client needs to be either a victim of domestic violence or abuse, or they need to be low income, sort of, below 200% of the federal poverty guidelines. For that definition of victim of domestic violence or abuse for eligibility purposes, we accept pretty much any type of victimization that we would talk about in the power and control, right? Like emotional, psychological, financial abuse, spiritual abuse, any type of abuse like that. That is not the broad definition that we have for the purposes of a protective order. The protective order is much more narrow of a definition of abuse, right? So it is in the statute. The definition for purposes of protective order defines domestic violence as one of these things. It is still pretty broad, but it's not as broad as, say, our eligibility definition of abuse and domestic violence, right? So let's go through these. These are super fun to talk about. Domestic violence includes commission or attempt to commit assault or aggravated assault. And each one of these definitions, by the way, in turn has its own legal definition. So if you ever are having trouble falling asleep at night, you might want to look up at the code and just read all of these definitions in the Utah code. Yes. Yeah, that's a good clarification, Brooke. So the ones that are bolded on this slide are the ones that are kind of the most common. The most common reasons why people might seek a protective order, but any of these could be the basis of a protective order if an act of domestic violence or abuse includes any of these things. So assault or aggravated assault, aggravated cruelty to an animal with intent to harass or threaten the other cohabitant. That's a fairly new one that's been added to the code. Because a lot of times abusers know that to control their partner, they can go through the animal like that or pet. So, and I did have a recent case of he had basically beat up the family dog. It was really scary. So that counts as domestic violence, but it does have to be with the intent to harass or threaten the client. They can't just have done it with clients, not there, it doesn't count. So criminal homicide, obviously, and it's any commission or attempt to commit any of these. Criminal homicide, harassment, the legal definition, who knows what the legal definition of harassment is? So it's it is the threat basically the threat of physical violence, the threat of physical attack. And so, like, if somebody tells their partner, I'm gonna kill you, or I'm gonna beat you up or something like that, that would be the legal definition of harassment under Utah law. Electronic communication harassment is a little bit different. That is defined as basically like spamming a person over and over without consent. So if your client says, please don't text me again right now I'm at work, or please stop contacting me, and they just keep texting or calling or contacting over and over and over an unreasonable number of times during a new period of time, that could be considered electronic communication harassment. Going down the list, kidnapping, child kidnapping, or aggravated kidnapping, mayhem. It's my favorite definition under the code. Does anybody know what mayhem is? Yes. It's cutting off like its ear or nose or lips or arm or leg. That's mayhem. I haven't had any of those cases yet. The mayhem case. Sexual offenses and sexual exploitation of a minor and aggravated sexual exploitation of a minor. Stalking. Important to know, and we say this a little bit later in the presentation too, but stalking is one of the basics for a civil protective order. And so if the parties are cohabitants, it's better to file a cohabitant protective order than it is to file a stalking injunction for a couple of reasons. One is a protective order is just easier to get. You don't have to file as much evidence to qualify for a stalking injunction. And so if the abuse has taken the form of stalking and the parties are cohabitants, file a cohabitant abuse protective order before you file a stalking injunction. Reserve stalking injunctions for, if the parties don't fit into the categories of the other protective orders. And stalking, who knows the definition of stalking and can share that? Anyone want to share the definition of stalking?
Two or more events that would put a reasonable person in fear for their safety or experience emotional distress. These can be direct or indirect or done through.
Very succinct and very good. Thank you. Yeah. So stalking, unlawful detention or unlawful detention of a minor. I had a client once who, whenever her husband would have an argument with her, and he would just start lecturing her and keeping her in the room with him and yelling, and he wouldn't let her leave until he was done. And sometimes it would go on for hours. And when she would get up to go, he would take her shoulders and push her back down so that she would sit and listen to him. That's unlawful detention. That's DV under the statute. So another iteration of unlawful detention might be taking away someone's keys so they can't leave the house, keeping them trapped in a room. That kind of thing is unlawful detention, and that counts as DV. Violation of a protective order or an ex parte protective order. Once the temporary order has been issued, or if there is a criminal protective order in place and that order has been violated, that is the basis for entering a civil protective order on a permanent basis. So that can be considered DV. I once got a protective order entered because the opposing party said hello to my client on the way into the courtroom for their hearing. That was a violation. So that was basically all we needed to say. It's not all I said, but it's all we theoretically needed to say to get that court to enter that protective order. Property destruction, burglary, criminal trespass, or robbery by one cohabitant against another is counts as DV. So if someone's cohabitant, boyfriend, husband, whatever, takes all of their clothes and throws them out on the lawn and sets them aflame, that's DV, right? That's one cohabitant against another for purposes of particular. Possession of a deadly weapon, criminal contempt, discharge of a firearm from a vehicle near a highway in the direction of any person, building, or vehicle, disorderly conduct. And disorderly conduct is that has its own obviously criminal definition, and that's it usually involves property destruction of some sort, and it also counts as DV if disorderly conduct is the result of a plea agreement in which the perpetrator was originally charged with a DV offense. Child abuse counts as DV, threatening the use of a dangerous weapon, threatening violence, tampering with a witness, retaliation against a witness or victim, unlawful distribution of an intimate image. This was also added fairly recently as part of the definition of DV. or unlawful distribution of a counterfeit intimate image, sexual battery, voyeurism, damage to or interruption of a communication device. That one's pretty common. I've had a lot of clients where they've been trying to contact emergency services on their phone, and the opposing party rips the phone out of their hands or destroys it or takes it away in some way. That is DB under the statute under this subsection, damage to or interruption of the communication device, and violation of a criminal protective order, which I don't know what he said, so. That is the definition of DV under the statute. A lot of times, it seems like perpetrators, they'll like know this and they'll dance right around it and be abusive in every way, except this, right? So that they're not getting in trouble. A lot of times, I'll have clients call the hotline or call services and say, yeah, I'm gonna get a protective order because my husband, boyfriend, whatever, is really abusive. And I'm like, okay, tell me about some of the abuse. Well, he threatens to take the kids all the time. He threatens to deport me. He threatens to divorce me. He calls me all these names. These are abusive things. These are terribly abusive things. Are they qualifying for a protective order under the statute? Not really, unless you can find that it's rising to the level of stalking, right? Something that Zod said a reasonable person would suffer emotional distress or fear for their safety or the safety of a third party. So that's kind of where we need to go and figure out whether it qualifies under the statute. Okay, so if a covenant of abuse protective order is granted, so what, a little bit about the process, yes. I'm gonna let you talk into the microphone. Hold on. Sorry, I don't want to put you on the spot. Is that okay? Okay.
Wanted to add that to the part about, abusers saying hurtful things to the victim. And what's unique about our protection order, the Appalachian Judicial Court, is that we have a section where victims can file protection order for financial abuse, emotional distress, and spiritual abuse too. We have a lot that goes on there, so I just wanted to add that. Our Navajo Nation rules of court proceedings incorporated that also for disabled, handicap, the elders, that type of abuse. So that's kind of amazing that we have that with them.
Thank you for sharing that. So that was with the tribal court system there, which is a separate and almost parallel system to our justice and district courts. And so if a client is a Native American and belongs to a tribe, it's worth figuring out whether they have those options under the tribal court system as well. Thank you for sharing that. Okay, so if someone, the process is that someone applies for the civil protective order through filing a request in the district court in the county in which either one of the parties resides or in which the abuse took place. They have all those options of where to file. It's in the district court. They file the request for the protective order. If the judge sees based on the request that abuse or domestic violence has happened, they will set a hearing and they'll issue the temporary protective order. And then if the protective order is granted at the hearing, the criminal, there's On the order, there's different numbered paragraphs of orders. And the first few paragraphs are criminal orders, and the next few are civil provisions. Those criminal provisions are in effect for 3 years. The civil portions, such as custody, parent time, child support, alimony, which I rarely see actually ordered in a protective order, child support or alimony, but it's happened multiple times. Those are for 350 days. If you want a more permanent solution for civil issues like child support, child custody, parent time, those kind of things, you're going to have to file a separate case, either a divorce or a custody case, to get temporary orders and extend those. They could call us, or they could call Legal Aid Society in Salt Lake or Utah Legal Services if they are interested in getting legal representation for that custody or divorce. I should mention as well that TLC does not do representation in court. We can provide advice on how drafting documents if people qualify, but for representation at a protective order, stopping injunction, or possibly for representation for divorce or custody, the client's going to need to call Legal Aid Society of Salt Lake if if the case is going to be filed in Salt Lake County, or if it's filed anywhere else in the state, they should call Utah Legal Services. Why are the custody orders important? Because without one, either parent has right to the child. If there's no order in place, either parent can, I don't want to say abscond with the child, but can take custody, physical custody of the child, and keep them until a court order is made. Questions at this moment? We're gonna, yes, Brooke.
And just emphasize with your clients, when we're talking about the civil provisions, with protective orders, you can ask for them, but just make sure that the primary purpose that they're asking for the protective order is to get the actual protection. I really don't like when clients, and it doesn't always happen, and I don't ever want to assume that, but if the judge or commissioner thinks that a client is coming in and their primary intent is to get the custody orders through that is really going to hurt their case. If you want to make sure that they're getting that protection, because there's civil remedies, we can get them a divorce or custody case, we can get that filed and get temporary orders. But I've just seen a lot of commissioners get really frustrated if they think that the primary issue is that they're trying to use it as a quick way to get custody. Because this is not supposed to be a quick substitute for that. This is for clients that are very fearful of their safety or the safety of their children. And there are provisions on that. I don't, for the custody and alimony, sounds like you've probably seen it more than I have. I've never seen alimony, and I've maybe seen child support entered one time.
Yeah, it only happened for me when the opposing party agreed to it as a stipulation. So, because in the statute, it says that both parties, it's either the statute or one of the court rules, it says that in order for the court to award child support or spousal support in a protective order action or a stop injunction action, both parties have to file a financial declaration with the court, and then I've never seen it happen. So the only time I've seen child support ordered as a part of a protective order was when the other party agreed to a temporary child support order as part of the protective order action. So we are going to take a little break now, maybe like 5 minutes, stretch your legs, use the bathroom if you need to. And there's going to be, after the break, we're going to discuss the other types of protective orders, including dating violence protective orders, child protective orders, workplace violence protective orders, sexual violence protective orders. There's so many now. When I started doing this, there was just cohabited abuse protective orders and child protective orders, but now there's several, so, and stopping injunctions. So take a break, and then we'll come back in about 5 minutes, okay?
to this. I know it's a lot of exciting material, protective orders and codes, but hope you enjoyed the break. Now we're gonna just break down some of the other types of protective orders. So the majority of the time, we're gonna be dealing probably with, sorry, over here, with cohabitant protective orders, but there are several different types and we'll briefly go over those. We also have some charts to really break it down, and so you can pull that up with your QR codes or they're online. See the clicker?
Yeah.
Doing.
Just keep presenting, you can use the clicker. This is
Perfect.
just for
Perfect. No,
reference.
no, you're good. Okay, yes. So after that, I'm glad we were able to go in detail in the cohabitant protective orders. Because that's most of what we'll be dealing with. There are also civil stalking injunctions. And so we briefly went over the definitions of what stalking was. But so stalking injunctions are different. For a cohabitant protective order, you just need to show that there was at least one incident of domestic violence to qualify for that type of order. The stalking injunction, you need to show at least 2 or more incidents of stalking that was directed at your victim. And stalking is the perpetrator knows or should have known that their actions would cause a reasonable person to fear for their safety or the safety of a third party or to suffer emotional distress. So we did briefly go over that definition. But so with the stalking injunctions, you need to attach the evidence of those stalking incidents to your petition and be prepared to present that at the trial or hearing. And so hearings for stalking injunctions are more complex. You're gonna you need to show more evidence. You need to show at least 2 or more instances. And unlike a cohabitant protective order for a lot of our districts, which are initially heard before commissioners and are under a different rule of proper, to get a civil stalking injunction, you're going straight before the judge, and it's essentially a mini trial, and you're gonna have to put everyone on the stand rather than proffering their testimony. So instead of saying, oh, I have my mom here, it calls to testify, I would proffer that she would say X, Y, and Z. Instead, you're gonna have to put her directly on the stand, and you're gonna need to be asking for questions. So it's a more complex process, and you're gonna be using the rules of evidence. And so if possible, that's why we say, if they qualify for a cohabitant protective order, do that first, because stalking injunctions are harder. It's harder to get help too, just because they have more prep time. And so if you're calling maybe some of our legal aid partners or organizations, you usually have to get on their schedule a little ahead of time rather than just having it on the regular protective order calendar. And so you need to be really specific when you're talking about stalking allegations. You need to describe what happened. You need to describe why it would cause that reasonable person to fear for their safety or to suffer that emotional distress. And then if you're granted, once you file the petition with the court, if you're granted that ex parte injunction, your temporary stalking injunction, the respondent, once they're served with it, has 10 days to request an evidentiary hearing. So it is possible you could get your stalking injunction without actually doing a hearing. That is a gamble. So a protective order, a cohabitant abuse protective order, you're always going to need to do a hearing. But it is possible that if the other side gets served and they say, great, I don't care, I never want to talk to this person again, and they don't request a hearing and it just becomes permanent, it's possible you could get your stalking injunction without a hearing. But we know how most stalkers are. They usually are not going to want that on their record, or they aren't going to want to have to deal with that. And usually they're going to want to come to court and test that. And so if they request the hearing after 10 days, they can still request a hearing and will get scheduled, but the burden shifts onto the respondent. And so they need to now prove that the stalking injunction should be dismissed or modified. So just let your clients know that even after the 10 days passes, they aren't completely off the hook. They could still request a hearing at that point. And so once you get these, it can last for 3 years. As we know, stalking is serious stuff. And so we can see the domestic violence when we're dealing with all the different protective orders, but I think it's always good to do more safety planning and be very thorough with our stalking injections. Because I think we know the stats as advocates and as partners dealing with these issues. Victims that are dealing with stalking, like this is where it can really escalate quickly. And we want to make sure that we are doing what we can to make sure that we get good orders, that we present good petitions to the court and present the evidence that's needed. Because I think with the opposing parties that I've dealt with in court, like the scariest ones are usually in the stalking injection, because usually it's not always like the ex-partner or the spouse, it's the weird person they've kind of gotten to know, and now they're just following them around, and this escalating behavior that might start as just phone calls or text messages ends up following them to their house, their work, their home. Like, for just as an attorney court, I'm just kind of thinking to some of the contentious interactions I've had with opposing parties, and it's usually been on stalking injunction. I've had to have like the bailiffs kind of get the opposing party out of my face, or have the judge like threaten the other parties and say, okay, we're gonna hold you in contempt of court. Like, you can't even, like, if you're harassing the opposing attorney and getting in their face and acting aggressive, like, it's pretty telling what's going on behind the scenes and what you're doing outside of court. So just be aware of these. There is an option that you can get for your parties, but if they do qualify for some type of protective order, I usually suggest doing that instead. Do we have, yeah?
Yeah, I just wanted to add to that sometimes it is very obvious that, as Brooke was describing, that the stalker is general and dangerous and threatening person. And sometimes it can be the opposite, that the individual incidents of the stalking viewed in isolation or out of context don't seem that threatening at all. And that may be the argument that the stalker makes. But the case law in Utah is very clear that the court is supposed to look at the complete course of conduct in its totality to see whether in context a reasonable person would find that course of conduct threatening or cause emotional distress, or cause that victim to fear for their safety. So it's important not to look at the incidents in isolation, but sort of the totality of the circumstances, the relationship between the parties, and the context.
Yes, thanks for adding that, because yeah, just one incident in itself might not be that scary, saying, oh, you got a text message, maybe it was blank, or maybe it just said hi. Why would that be scary? But if you look at the whole course of the relationship and that whole course of conduct, that's what the court's going to be deciding the stalking injunction on. And usually these ones, we're going to be having a lot of evidence. So you might be having pages and pages or binders full of screenshots or emails, because there is usually a lot of contact. And so if you can hang on to that evidence, make sure that the client also saves it somewhere else, because I know whenever they have it saved on just their phone and they have messages between them and their abuser, they usually end up losing that phone, or the phone breaks, or it falls in the toilet. Like, I just feel like I've had this happen so many times. And so if there's a good way where they can save it or email it to themselves or save it externally, just make sure that it's not only saved on the client's phone, because there's been so many times where they might have a really good case, but unfortunately their phone gets destroyed and that was their only source of the evidence. And then it's really hard to prove that course of conduct in court. There we go. Okay, child abuse protective orders. So these ones are tricky. And unfortunately, unlike the rest of the protective orders that run for 3 years, these are the shortest ones, assuming it's entered against a parent or guardian. So they need to first report to DCFS. These cases are not really going to go anywhere if DCFS is not involved. And so you need to either show that the child is physically or sexually being abused by anyone, so there needs to be current abuse, or the child has been abused by someone other than the parent or guardian. So there's a higher standard for the abuse in child abuse protective orders. Unlike cohabitant abuse protective orders where you can say, as long as there's been one incident of abuse, you can qualify. There's not a timeline or restriction. Usually the language, I believe, says immediate and irreparable harm. So especially if it's against a parent or guardian. So you need to show that there's an ongoing threat to the child. DCFS is involved. It needs to be pretty serious. And so once you have that hearing, if it does get entered, if it's against a parent or guardian, it lasts for up to 150 days. That is a very short time. And so you will also want to be having a case either going ahead, hopefully maybe there's something in juvenile court, or getting like a custody modification in a divorce or custody case and getting them in for some temporary orders right away. It's really hard and frustrating to tell clients they go through all this effort and having to have the hearing, and then if they do get it, it's a very short time and you're having to go right back to court and trying to get some other orders in a civil case. And if it's against someone else, it can last until the child is 18. Do we have any comments or questions about child protective orders? I don't know how often all of you guys are dealing with the child protective orders. Usually it's kind of tied to the custody and divorce cases. Yes.
So if the suspect is also a child, does it go until the child is 18 if they're not like a family member?
My experience has been yes. Yeah, so the question was, if the perpetrator is also a child and it gets entered against that person, does it go until they're 18? I think it often depends on the judge. I don't know if anyone's had other experience. Sometimes it's complicated when maybe it's two kids that go to the same school. I've seen different things entered, but I believe under the statute that at least if it's granted, it should be able to run until the victim is 18. Have you had any other experience or seen them expire? Yeah. So I think you argue that it goes till 18, but it's possible it might be a shorter time on the order. Yes, and unfortunately, the tricky part about these two is typically our partners, Utah Legal Services and Legal Aid Society, usually don't represent on these because they are more complicated and usually they're in juvenile court, and so they're usually sending people to district court. And so the only times I've done when I was at Utah Legal Services a child protective order, I think it was because I had a victim that filed a protective order against her husband. He filed one against her, then they filed one for the child. And then there was also a divorce case. And because it was so complex and tied together, and since the court set all three protective orders at the same hearing date, we were able to represent on that just because there was no way to actually separate the cases when there were three hearings being heard at the same time. But normally you aren't going to be able to get help through those organizations. So you can, there are other resources. You can talk to like the Bars Pro Bono program. You can come to Timpanogos Legal Center. You can give advice. We can refer you to some other attorneys. We have a list of sliding scale attorneys that might like to do it on a lower scale basis if we have a question about it. Sorry, what? Sure, I'm gonna hand you the mic really quick.
So I'm with Legal Aid and we help as long as it's against a parent or guardian, but if it's not, then they have to go up to juvenile court. And then also the other part we have to have jurisdiction in district, is there has to be a parentage action with custody action or divorce action to attach to. That's for anyone that's trying to file an issue. If they don't have that, and it's against anyone other than a parent or guardian, it goes to juvenile.
Thank you for adding that. So that's another good option. I didn't realize you were doing those in those circumstances. So at least so there's some other options there, but that's why we can see that child abuse protective orders are harder, and it's also harder to get help just because not as many people do it in juvenile court. It's complicated. So And I wish that these ran longer, unfortunately. And we also have dating violence protective orders. So this is to help victims that fall short of qualifying for the cohabitant abuse protective order. And so these are aimed at parties that are over 18 and they're in a dating relationship and they are a victim of dating violence. So I like sharing this one because they have interesting definitions. I think we would all maybe define dating differently. And so I just kind of laughed that they had to define this in the statute, but the dating relationship is a social relationship of a romantic or intimate nature, or a relationship which has romance or intimacy as a goal by one or both parties, regardless of whether the relationship involves sexual intimacy. And so this is for parties that wouldn't qualify as consensual sexual partners under the cohabitant abuse protective order. And so dating violence, there's not really an actual definition of that. Generally, it just includes what falls under the previous definition of domestic violence that we covered in all those different crimes. And so if you do qualify and if you do get an order entered at court, this one lasts for 3 years. Have you guys seen these very often? I think I've only done 1 or 2. And I just get a raise of hand if anyone has actually had clients get a dating violence protective order. Okay, so we've had some people here, not as many. Obviously, less than half of the advocates here have actually had clients get some. So this is more rare. I think most people are getting cohabitant abuse protective orders, but so this is at least a good option for parties that can't get that. I remember my very first case in court when I was doing protective orders was a dating violence protective order, and none of the other attorneys had like done it before, and it was the new statute, and they're like, well, good luck, we'll see how this goes. We didn't end up getting it, but that's because there were lots of, and there was confusion under the code of what qualified. So, yes.
So there's the case of an emancipated child, let's say 16, or, you know, will not qualify for that.
For a dating violence protective order?
Let's say that if they're an emancipated child.
Yeah, so would an emancipated child that is not yet 18 qualify for this? I don't, have you seen that happen before? Yeah, I can.
They not.
Okay, so.
And so. Similarly, yeah, the cohabitant protective order, I don't know how strict they would. I think that the court might say no if they are over 18. And so this one's kind of a weird one. Good question.
Or a minor tag. Figuring out what you want.
Sorry, do you want me to repeat the question? Okay, so he asked, so if there's an emancipated child that's 16 and does not yet meet the 18 plus requirement for a dating violence protective order, what can they do? Can they qualify for this? And so they can do the Cohabitant Abuse Protective Order Act since they're emancipated. And if they, and Alex mentioned, like, if it's been a consensual sexual relationship or if they've had sex, then you can do the cohabitant abuse protective order. I just have not seen this issue litigated in court, and I don't know what the judge would say. I think it's possible they might say they don't have jurisdiction for a minor that's not yet 18, but there might be some other options depending on the facts of the case. Maybe they could do the child PO. They could also maybe do a stalking injunction if the facts set up. We can talk about some of the other types, but I have not seen that come up in court. Okay, Kat, I think we are back to you.
Okay, the sexual violence protective order. You'll be over 18 plus, and sexual violence must have occurred, and like so many other things. Sexual violence is defined in the code and has a legal definition, but we have a comment up here. Let me bring you the mic, hold on.
Okay, so with these, it says must be 18 on the forms, but the statute does not actually list an age. So legal aid just litigated a case with the person was 16. And we were able to get it, and we've gone in front of the forms committee, and they have agreed to change the forms, and they are now updated on the site. So there's not an age listed, so you can do them under 18 now for sexual violence.
Yeah, you're right. So, forget that part. You don't have to be 18 plus. If you meet the other requirements of a sexual violence protective order. Now, if the parties are cohabitants, any of this sexual violence is gonna, or I should say, almost all of the sexual violence definitions here are gonna fall under the cohabitant abuse protective order as well. So we file that first, but if the parties are not cohabitants and sexual violence has occurred, go with the sexual violence protective order. Sexual violence in the code includes all of these offenses, human trafficking for sexual exploitation. That's one that I don't think is under the definition of DV, under the cohabitant abuse protective order. So that would be an exception where you would need to file a sexual violence protective order. But rape, object rape, forcible sodomy, forcible sexual abuse, sexual assault. All of those would also qualify for a cohabitant abuse protective order if the parties are cohabitants. Sexual exploitation of a vulnerable adult, and a vulnerable adult is, somebody correct me if I'm wrong about this, I'm just going off memory, but I believe it's anyone 65 or older would be considered a vulnerable adult, as well as anyone 18 plus with substantial disabilities that would make that person unable to perform some of the daily functions of living. So that if they have a disability and are an adult, they'd be considered a vulnerable adult, or anyone 65 or older. Distribution of an intimate image or unlawful distribution of a counterfeit intimate image are included here, and sexual extortion. I did have someone call, I think it was when I was still at ULS, someone called our intake, and their landlord, who lived in a separate dwelling, so not cohabitants, but their landlord had asked them for sexual favors in exchange for discounting the rent or letting her skip rent or relate on something like that. And that would fit under the sexual violence protective order, because that's sexual extortion. So otherwise they weren't cohabitants or anything like that, but that kind of behavior was sexual extortion, so she could apply for a sexual violence protective order in that situation. Yes, Rochelle.
Okay, so 2 online questions, and I'll ask the first one. It says, in this order or the other protective orders, some non-documented clients are fearful of themselves or their undocumented perpetrators being deported due to bringing this into the courts. What would you say to those clients?
So what I always said to people who had that concern of an undocumented victim or survivor who was afraid to bring one of these civil orders to court for fear of being deported or having their perpetrator be deported, I always said that this is a civil matter. This is not a criminal court. I have never known for that to be brought up by the court. I've never known for anyone to be reported to ICE or anything like that because of bringing a civil protective order or being involved in a civil protective order. But having said that, I can't 100% guarantee that that's not going to happen. I've never seen it, but I can't guarantee that that's not going to be part of what happens. Or did you have something else? Okay.
Okay, the second question is regarding sexual violence protective orders.
does there have to be assault charges filed to prove the sexual violence occurred?
No, I don't think that's not a requirement of the sexual violence protective order. It doesn't preclude it. Of course, you can do both at the same time. You can report the crime to law enforcement at the same time that you are filing a civil sexual violence protective order. It's not a requirement under statute, but in order to file for a sexual violence protective order, you have to have charges filed against the perpetrator. And that's generally true for all of these civil orders. Is the point of having a civil order is that a layperson who may or may not have reported things to law enforcement can go and ask the court for a civil remedy outside of and parallel to the criminal remedies that are also available. Any other comments or questions before we go on? Okay. As with most of the other civil protective orders, if the sexual violence protective order is entered, it lasts for 3 years. This is brand new. The workplace violence protective order is effective and should be available starting July 1st. So just in a little over a week here. And the big difference with this one is that not anyone can seek it, only an employer can seek a workplace violence protective order. So if you are an employee and you've experienced workplace violence, you may not file a workplace violence protective order. Only your employer can file it on your behalf. If you are an employee and you've experienced workplace violence, you do have another remedy, which is that we've just talked about. Anyone? So if you're an employee, you've experienced violence from a coworker, you can't file this because you're not the employer, but you could file potentially what? You can do a stalking injunction, yeah. But not with one incident. There has to be at least 2 incidents. That's correct. It's like to be, yeah, report that to HR. If there's an HR department in your workplace, and if not, go on Twitter and complain about your workplace a lot, I guess. So the workplace violence protective order, an employer may seek a workplace violence protective order if they reasonably believe that workplace violence occurred against the employer or an employee. Workplace violence is defined as knowingly causing or threatening to cause bodily injury or significant damage to property against the employer or an employee, and the action would cause a reasonable person to feel terrorized, frightened, intimidated, or harassed, or a reasonable person to feel terrorized, frightened. Not the exact same thing I just said, or a reasonable person would fear that the threat would be carried out, and if carried out, it would cause a reasonable person to feel terrorized, frightened, intimidated, or harassed. If there's a specific individual targeted, the petitioner has a duty, so the employer has a duty to make a good faith effort to notify that individual that they're filing the workplace violence protective order. And it expires automatically after a period the court determines not to exceed 18 months. Since these are brand new, nobody has any experience with them yet, obviously, but it'll be interesting to see how many are filed and how they're dealt with in court. For the person who does just have one incident of workplace violence, of course, with one incident, they can't file a workplace violence protective order because they're an employee, and they can't file a stalking injunction because there's just been one incident. But if the act or the incident is already a crime, in other words, if it's, for example, a threat of violence, if it's a threat to commit a felony, if it is you know, actual violence, like an assault or something like that, they can always report that to the police as well as HR. And if they do report to the police, a lot of times, with clients, potential clients who don't have 2 incidents yet for a stalking injunction, but they have 1 threatening or scary incident that's happened, I usually counsel people to report that to law enforcement, so that at least they have a police report. And they can ask the police specifically, can you please tell this person that I don't want any contact with them, and please not to contact me anymore. And then that is good preparation. If the second incident does occur, then they have that good documentation that they've reported to law enforcement already. They have a police report, and they can show with their file with their single stalking injunction request. Any questions or comments about the workplace violence?
Well, I wonder how that would be related to Item 7, but let's say I'm the employee and I decide to go to the labor commission and file a discrimination based on Title 7. And how would that be related to the protective order if I feel the order? You know what I'm saying? How would that?
Yeah, that's a really good question. I don't know really the answer to that. I assume that it's just gonna proceed kind of on parallel tracks, because you can, I'm not assuming you can do both at once, right? So we'll just have to see where it stands. Yes, yeah, no, that's a really good point. So this is one of the things that potentially we can discuss at Advocate Connect. Another plug for Advocate Connect. Please come and share your stories, share your experiences, so that we can be preparing and better help serve clients and help them know what to expect. Restraining orders. A lot of times people in other states talk about restraining orders, referring to things that we would call protective orders. In Utah, a restraining order is different from a protective order. A restraining order is not usually a standalone case with a case number. It's typically part of a divorce or custody case. It'll be a provision in the temporary order in a divorce or custody case, or in the final divorce decree or custody decree. There may be, and it may not have a title that says restraining order in it. It may just say, have a paragraph that says both parties are restrained from blah, blah, blah. And that they may be one-sided or they may be mutual restraining orders, right? If it says both parties are restrained from doing blah, 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 that's a mutual restraining order of both parties. But if it's on one side, it might say the petitioner is restrained from, or respondent is restrained from. And it may have a lot of the same verbiage or provisions, substantive issues as a protective order would have, but the mechanism for enforcing it is different. So with a protective order, if your client has a cohabited abuse protective order, for example, those first few paragraphs that are criminal portions of the civil protective order can be enforced by law enforcement and should be reported to law enforcement if the opposing party violates that. So if the cohabited abuse protective order says respondent may not contact the petitioner in any way, and respondent sends petitioner a text message, petitioner can report that to law enforcement, and that's a crime. That contact, because the protective order is in place, is a crime. It can be reported as a crime. The police can arrest the perpetrator for contacting the victim, and they can go to jail, or the other criminal penalties can be imposed. On the other hand, a restraining order in a civil case, in a divorce, in a custody case, that restrains one party or both parties cannot be enforced by the police or law enforcement. It must be enforced by a motion to enforce filed in the court, right, rather than the same case. So it lasts until modified by the court, so potentially it lasts forever. Or it can have its own provision in there saying that it's, you know, that provision is gonna expire in 3 years after the divorce or 5 years. I mean, I don't see that very often. Usually they're permanent if they're entered in a divorce or custody case. But that's what a restraining order is. A lot of times, not a lot of times, but sometimes, often, let's say that a cohabitant abuse protective order is filed. We go to court, the parties start negotiating, and they say, look, let's dismiss the protective order, but I will agree to a mutual restraining order in the divorce case that's already been filed. And a lot of times that is a good option, for a client. If the evidence is not great, if they're not sure whether they are going to get the criminal protective, sorry, the civil protective order in the hearing, a mutual restraining order that the opposing party agrees to might be a good option in that case. So that is the story on mutual restraining orders or restraining orders in general. Anybody have a question or comment about that? Yes.
So restraining orders are different in the fact that they're a regular type of protective order, and we have unfortunately seen sometimes that a lot of clients dismiss their protective orders that they get into it, maybe in divorce mediation. And I don't want to say these are completely garbage, because there are parts that can be useful, but they aren't helpful in the sense that they aren't a statewide network. If you call 911, like, it's not gonna flag, like, you have a protective order and you can't be arrested on the spot. And we all know how quickly you get into court and have a hearing. Just kidding, I'm being sarcastic. So if you need to enforce it and they're contacting you, you need to set that hearing, wait and get into court and then see what they do. And so it's not that helpful if you actually need the protection. I think it's important to explain that to the clients to know what they're giving up if they do dismiss it, because we have unfortunately seen kind of an influx of these cases where maybe they get talked into it by another attorney or a mediation to think, okay, I can get this out of the way, and that might be a really big thing for the other party. They don't want to have the protective order on their record. And I was just going to add like 1 or 2 more things. This is, I think, a really hard part of being either an attorney in this area or an advocate. At least for being an attorney, you have to represent your client's interests, and they are often not in their own best interest. And so this is where it can be hard, and you have to explain the different ramifications to the client. And so maybe they might know that, oh, if this client, if I get a protective order, this might make my partner lose their job. Because now they can't have the background check that they need or be able to carry a weapon. I feel like there's so many cases where they're like, I'm an officer, or I'm a security guy, I'm a gun, like, I don't know, like they always have these jobs that like tie into needing to have clearance. And so the client will often think and say, well, what's more important to me right now? As a single parent trying to navigate this process, do I want to be able to have my ex with a good job where they can pay me alimony or child support? Or do I want him to get fired and I might not ever get any support? So that sometimes becomes what the client makes their choice about. And it's very sad, and often they're very serious domestic violence situations and they decide to dismiss the protective order. And so it's very hard. And I've had cases like that where they decide, well, right now the child support is more important to me than the protective order. And it's really hard when you have to dismiss those cases. But that's where advocates can come in, and you can kind of talk and you can explain why they needed to do that safety planning. We're just more restricted, I think, as attorneys to make sure we're representing their interest and do what they want, because we have rules under the bar we have to follow. But that's kind of just my soapbox. I wanted to add, it is very hard, but I think just explaining the different ramifications to the clients so they're clear what they're getting or not getting.
Okay, we have an online question, and it's from Pam, and she says it might be a silly question, but no silly question. So, but she wants to know, what would be the difference for a domestic injunction to enter in a divorce with similar provisions of appeal would that only be entered until the divorce decree is finalized? So if they wanted a mutual restraint to apply after the decree is finalized, would that be a specific provision in the final divorce decree?
Yes. So very simply, yes. So the domestic injunction that is filed, I think that what they're referring to is a few years ago, I don't know, all time runs together for me, so I have no idea how long ago, but like, I don't know, 5 years ago, 5, who knows? Yeah, I don't know. At some point, the legislature passed this thing where, when any, divorce or custody case begins, there's a domestic relations injunction that automatically issues, and it has certain provisions in it that like don't abuse the other person, don't cut off the utilities of the other person without specific consent or in writing, that kind of thing. And that automatically issues by the court and is enforceable by a motion to enforce that you would file with the court. But those go away once the case is finalized. So yes, if you do want those specific injunctions or similar injunctions or any injunction or restraining order to continue past the finalization of the case, you need to put it specifically in that paperwork in the petition that you want a certain restraining order as part of the order. There's something else I was going to say. Oh, circling back to Brooke's point, which was very good about it is a lot harder to enforce these. It's a lot more time and effort to enforce a restraining order or any order of the court, any civil order of the court, than it is to enforce a protective order that it can be, you can just call the police and work. So that is something that if you're an attorney or a licensed paralegal practitioner or a CAP advocate and can give legal advice, that is something that you need to make sure that a client is well advised and thoroughly advised on, that they understand what they're giving up. If you are not one of those things and you can't give legal advice and can just get legal information, it might be important if someone is thinking about dismissing their protective order in exchange for a mutual restraining order, say, you might want to talk to an attorney about this. That's completely fair. And I also recognize that, as we all know, working with victims, ultimately, we can't take their power away from them. We can't take their choices away from them. And so our responsibility is either to give them that thorough advice and let them choose on their own what they want to do with that advice, or advise them to speak with an attorney who can give them that advice and help them to make an informed and complete decision. But we didn't, I mean, yeah, there are a lot of times when I think my clients have been making the wrong choice. But ultimately, we have to realize our boundaries and give them, empower them to make choices. Them knowing and understanding their own situation and understanding the ramifications or potential ramifications of those choices. Anyone else want to comment? Yes. Hold on a second, let me get you mic.
One of the consequences with the petitioner is the person who don't fulfill the protection order.
That's an excellent question. So a civil protective order, so mutual restraining orders might restrain both parties. Okay, and if the document says both parties are restrained from, both parties are equally obligated to follow that order. In a civil protective order, if it says, for example, respondent may not contact petitioner, that doesn't mean petitioner can't contact respondent. Petitioner is allowed to contact respondent. They're not going to be arrested if they do. They're not going to, you know, it's not a crime to contact the respondent. However, if they do contact the respondent after that protective order has been issued, it does show the court that they may not be in fear of the respondent, or at least that's how the court's going to interpret it. And so if they do that, if they contact the respondent or violate the protective order in that way, the respondent may bring the petitioner back to court and say, look, they've contacted me all these times, they're acting in contravention to the protective order. Dismiss the protective order because clearly they are not afraid of me. Okay, so that's the potential consequence if the petitioner violates the other way. Any other questions or comments before we move on? And Brooke, you're gonna have to tell me where we're supposed to switch, because I don't know. Is it the next one? Okay.
We're gonna go through one more section here and then we're gonna take another break. So these are just kind of some general tips and things that I want you guys to think about and remember. So when you're preparing forms, Legal Aid Society of Utah Legal Services have attorneys that can help victims draft and file their protective order request. And so the clients still have to go through their intake process. And so you can refer them to legal aid for cases that will be filed in Salt Lake County. And for everyone else, they can go to Utah Legal Services. And so yes, this is a newer service. So be aware of what they have at Utah Legal Services. This is a new thing that they're doing. So try giving them a call and see if they can help them draft the petition at the beginning. And if there's a CAP advocate in your area, you can refer back to that map that we had, reach out and see if maybe they can help your client prepare their forms. And so if not, another option, if they're pro se, they can use OCAP, which is the online court assistance program. I'm sure you're all familiar with the court's website. They can draft the forms and put them in the computer, and they spit out the protective order petition, and they can take it and file it with the court. Or they can download the forms separately as templates on the Utah Court's website. Just be aware, this is free. There's not a filing fee for a protective order. If you ever hear a client's being charged a fee, let us know, let the court know, because they should not be charging for that. And as advocates, you can assist your clients, but you cannot give legal advice. And so TLC, we're happy to coach or review the forms if needed for the client. Typically don't help them draft the protective order petitions just because they have to go through these different options that they are available online. And if your client is trying to decide which protective order they qualify for, if you have questions, give us a call, or your client can call us directly. So that filing and service is free. So if you ever hear of someone being charged for service, let us know. I don't know if they need to do like out of state service. Do you know if they charge for that? I think they do. Is it yes. Yeah, so you might end up getting charged maybe if the opposing party lives in a different state and the Utah courts can't cover it. But if you're in Utah, you should be able to get service, and typically the sheriffs do that, and you can do it for free. When we're talking about timelines, just as soon as you get that filed and get an ex parte order with your hearing date, if you're wanting representation, reach out to the Lane and Utah Legal Services right away if you haven't already done so, because these cases move fast. They have a very quick timeline, and you know that there's not enough legal help to go around, at least free legal help. So if you're wanting to try and qualify for these services, all of their attorneys have massive caseloads and a lot on their plate. And so if you want to see if they can take your case and get on their calendar, you need to call them right away. You can't call them the morning of and say, hey, I'm out in Vernal, can you guys come and represent me on a case? They are generally going to say, no, we can't drive out 3 hours right away and represent you. So don't delay in these. Then also when you get to court, if you maybe have your protective order denied, but there's a good reason why you want to try and maybe appeal that, you're wanting to object to the commissioner's recommendation, you need to do that right away. There's a 14-day deadline. You need to file the motion and object to it. There are forms available on the court website. If you can't find those, we can send you the template. And so you need to explain the reason why you disagree with the commissioner's recommendation, and you can object and then have another hearing before the judge.
Oh, I was also going to say that if the initial request for protective order gets denied, you can still object within 5 days and ask for a hearing to determine whether the temporary protective order should be lifted.
Yes, thank you. So all of these deadlines are very important. So just make sure that your client's on top of their game, because they can't just set it aside and say, oh, I didn't think about this and now I need to draft this and try and get it in the night before. Okay, so with the cohabitant abuse protective orders, you can file even if you haven't left the house or the relationship. I think we had a discussion with some advocates that have seen like judges pushing back saying, well, they probably don't need it because they actually haven't left the house or they're still in a relationship with the other party. That is false. You can also still file even if a divorce case has not been filed yet. You do not need to file a divorce, or it doesn't need to be before a certain time. Most parties usually file the divorce after they get a protective order. So those are not requirements for filing a temporary protective order. And with the protective orders, as we said before, you file it where they reside, where you're temporarily domiciled, or where the abuse took place. And then just another reminder, we said this before, stalking injunctions are hard to get, especially without legal representation, because it involves a lot more of the rules of evidence. You're putting everyone on the stand, you're calling witnesses. And so that's why we say if you get the protective order, go through that first, and you only need to show the one incident rather than the two in the pattern of conduct that you get in the stalking injunction. And so with the protective order, you also get more protections that you can get. And you can kind of add different options. There's more on the forms that you can ask for than just on the stalking injunction. Okay, and so make sure when your client is filling out the form that they check all the boxes that they want. They can't go back and add more down the road. So maybe they just check one or two, and then they get to the hearing and they say, oh, Your Honor, I changed my mind. I now want to check all the dozen boxes that are on here. They're going to say, no, you would need to amend your petition prior to the hearing, and the opposing party would need to be served with it. You can only ask for fewer protections at the hearing. You can't add more to your wish list. I've seen different things about personal conduct orders. Usually they aren't too helpful. This is where we're talking about if someone files a protective order and they only check the first box that says personal conduct, which pretty much says do not commit domestic violence. It's like do not break the law. So you really shouldn't need an order to say to someone else, don't break the law, and if you do, you're violating this, but you're already violating the law. If someone really wants a protective order, I want to try and get them more protection in that, like don't come to their house or don't contact them, rather than just having these ones, because they're very hard to enforce. And it doesn't give them a whole lot more. You're kind of going through a big hassle in a hearing just to try and get an order that says don't break the law. I've also seen different things about the stay away orders. I think what's the default on there? It says 500 feet, but I've seen commissioners cross it out and write in other things like 100 feet, 200 feet. It can be harder to enforce like a radius of how close the other party can come to you, especially if the parties live next door. That's hard to enforce. They might just clarify and say, don't go on the victim's property at all, don't go in their driveway, only stay on public streets. So it can get more complicated depending on kind of the nature of where the victims live, where they work. So sometimes I'll see that written in, but just be aware there's not like a default. When we're talking about describing the incidents of abuse, make sure that you describe in the course of conduct what's happened in the relationship. You don't need to say everything that's ever happened and say it's the course of a 20-year relationship. Give it a vivid picture of what's happening and why the client is scared and needs that protection. Describe the most serious incidents and kind of say, over the years, there's been X, Y, and Z, there's been these types of abuse. You want to give enough that you can present that in the court, because you can only pull up and allege the incidents that are listed in your petition. You can't just start naming different things in court, because you won't be able to address that. You don't want to just do the most recent, you want to include the evidence that's reasonable. Address things that are serious, especially if there's been physical violence or threats of physical violence. Usually I say, don't waste your time coming on to this next point. You can add the context if there's been emotional abuse, but you aren't going to qualify for a protective order basically. You can maybe just briefly mention and say, in addition to the serious domestic violence that happened on these 3 dates, there's also been 20 years of emotional and mental abuse, but don't fixate on that. Sometimes I'll see parties go on for 20 pages in their petition complaining about everything that their ex has ever done. That is not helpful, and it usually just upsets the court when you're wasting lots of pages that aren't necessary and they don't fit the statute. So that's what you always want to do, is look back and fit the statute. So emotional abuse isn't enough. If your petition only says they were name calling, they were swearing at me, they were accusing the other of cheating, they were threatening to take the kids away, that's not enough. Same with financial abuse, although we did hear about the protective orders and Navajo Nation, and that's great. We just, for our protective orders here in Utah, we just have to make sure that we qualify under the statute. And so also gather your evidence, your photos, police reports, witness statements, pictures of property damage. That can be very useful if maybe the respondent punched a hole in the wall, take a picture of that and attach that. That is property damage. You want to be specific, give approximate dates and places, even if you don't know the exact date. It just helps to try and add more detail. The better you can describe how things happen, the more helpful it is to the court. You can't just say, oh, one time he punched me. I have no recollection which state we were in, where we were living, what date it was. That's really hard for a court to determine, especially when the other side gets to present their side in their testimony. Just remember, it's the other side gets to defend themselves. So you need to have good testimony, good evidence. A lot of the commissioners or the judges say, play the movie for me in my mind so I can see what you're talking about. And just try and leave out the irrelevant information. So I think we are going to take a break right here. Which what is this? Does it show the number? Yes. Okay, and if you're okay, we're going to take just a really quick break and then come back and kind of fly through the rest of this information. We have a time. 11:15, be back here.
By that time, so I want to get started again. And hopefully we get through the material we have, but I do want to encourage questions and comments. I think that's really helpful. And I want to, we both want to talk about the things that are most important to you, for sure. So let us know. As part of filing a protective order, you need to list on the request, there's a space specifically there, and if you're going through OPAP, it prompts you to do this. But there's a space to include all previous cases that have been filed that have to do with any cases between the parties, any prior protective orders, divorce cases involving the parties, criminal cases involving the parties, or if the parties have children involving the party's child. So that includes any prior protective orders, divorce case, custody case, parentage case. Sometimes clients forget any criminal cases that either party has pending or previously been convicted of domestic violence, for example. Those are important to include. Basically, the idea behind this is the judge or commissioner doesn't want to be ignorant of any other proceedings that are going on or that have gone on between the parties or regarding the parties' children. So it's really important to include those case numbers and the information about those cases on the request for the protective order, so that the court is aware of what other things are going on. And it does affect the court's perception of the client's credibility if those are left off, even inadvertently. So we did have this example happen to one of our clients, or a client, maybe it was a former client at ULS, I don't know which, but There was a victim who had an advocate help her fill out the paperwork, and the advocate didn't include any case numbers. And so the commissioner said that she couldn't find the client credible because she had filed 3 other orders and failed to mention them in the request. And the victim was ordered to pay the other side's attorney's fees because of this. So it's really, really important that in this section and the other sections of the request for the protective order, that you are thorough and complete in answering the questions that are on that form. We don't have a client by, obviously, don't have a client line. Providing a comprehensive look. So make sure to include all the incidents of DV. Again, this is domestic violence as defined by the statute that we discussed earlier. Sometimes it's tempting to just list one incident, maybe the most intense or severe incident of abuse in the request. But don't do that because you never know what incident. First of all, the request asks you to list all of the incidents. And so in the interest of being honest and having candor with the court, it's important to list everything. For another thing, you never know which incident is going to convince the courts or be convincing to them. And so it's important to list everything. Plus there's something called res judicata, that is a Latin term for something that's already been settled or already been decided. Which basically just means if I go and I file for a protective order and I list incidents A through E, and that request gets dismissed for a reason, any reason after a hearing, then I can't come back to court and ask for a protective order with incidents A through E again. I can list those in addition if I have a new incident that happens later down the road, but I can't just come back and file the exact same allegations again and try to get a new hearing. That's something that is not allowed. So be very careful and thorough because it's kind of like you get one shot at this, and if that shot fails, you have to wait for something else to happen in order to file another protective order to have another bite at the apple. So do include what evidence you have. If you have text messages, for example, screenshots of text messages where the perpetrator is threatening the survivor, is threatening abuse, threatening violence. Please attach those to the protective order. If you have photographs of injuries, if you have a video of abuse or domestic violence, contact the court clerk to see how you can get that video in front of the judge or commissioner. Because that's something that obviously you can't submit at this time through OPAP or through email to file with the court. Police reports, there's another thing that is possible to attach. If you have other witnesses, you can have them file affidavits along with the protective order as well. Filing a protective order, yes. Yes, in addition to, Brooke reminded me that in addition to having them file affidavits at the beginning of the case, you should make sure that those witnesses are available to come to court for the hearing. Filing a protective order, just like separating or, a lot of things we know can be escalators for abusers. And so make sure that you're doing it right the first time and being thorough so that you really want to, what's that phrase? Like, if you're going to kill the king, you better not miss, right? Like you have this one shot and you need to do the best that you can do because it can be more dangerous for the client afterward, after a failed protective order attempt, if you just don't have the evidence or don't have everything listed there. So, and then, you have the risk of not getting representation if your request is poorly written or if you don't have included evidence. Length of time since the abuse. So in the statute, it says specifically that a lapse of time between the abuse and the filing of the protective order cannot be the sole basis for rejecting a protective or denying a protective order. it doesn't mean that the court can't take that into consideration when they're trying to evaluate credibility. So they will look at a lapse of time. If the only incident of abuse was 10 years ago, and your client is filing for a protective order now, the court's gonna wanna know why. There may be a perfectly legitimate reason for waiting that long. And so it's not in and of itself going to tank your opportunity for a protective order, but you should be prepared to explain that lapse of time in the request. It might be for a variety of legitimate reasons that the client has decided to wait to file for a protective order. And so, just be prepared to explain that both in the request and perhaps at the hearing as well. If you do have an appeal go wrong for a client, we appreciate feedback on, as TLC attorneys, we're always trying to kind of gauge what's going on on the ground, so to speak, in the field. And so if you have a PO denied and it's surprising why it was denied, or if a particular judge keeps doing the same thing and you don't think it's in accordance with the statute, that's something we would like to know so that we can be aware. We can maybe kind of try to figure out whether a judge needs education or whether maybe an appeal might be appropriate, or if we just need to adjust the way that we give advice too in a certain area. So that's something that's really helpful for us. At the hearing, appeal can be entered without a finding of fault if it helps. So I've done this a lot as an attorney. I'll get there and the opposing party is there and I'll say, look, do you agree that that you guys shouldn't have any contacts? Sometimes they'll say yes, and I'll say, we will agree to the protective order entering without a finding of fault if you're more comfortable with that, rather than having to go through the whole hearing, put on all of our evidence that we have. If you just want to stipulate to the entry of the order without a finding of fault, we would be willing to do that. Now, what is the difference between a protective order entered without a finding of fault and with? The only real difference is that all of the orders are exactly the same and can be enforced in the same way. It's just that a protective order entered without a finding of fault can't be used against the perpetrator in a criminal case that they might have, for example. So if they do get a protective order against them after a hearing, the criminal prosecutor can say, look, they had this protective order entered against them, and the criminal case can take that into consideration. If a client decides to dismiss a protective order in the hearing and you have the ability to give them legal advice, please advise them or ask the court to dismiss without prejudice. Have that on the record so that you can bring up the same allegations again in the future if needed. All right. Yes, yeah.
How does one advise on dueling protective orders? Example, there's a criminal PO in place and then the respondent of that PO retaliates and files a civil PO. Ideally, they should disclose if there's another PO in place, but that doesn't always follow.
Yeah, so that's a good question. So first of all, if someone does file a civil protective order and doesn't list other cases, criminal cases or otherwise, that's something that the attorney or the petitioner can bring up at the hearing, say, look, the other party has this other case, they're aware of the other case, they didn't disclose that to the court. So that hurts other parties' credibility. You can't trust them because they didn't disclose that to the court. And then in addition, the law does allow for mutual protective orders to be entered against both parties, but only if there has been abuse on both sides and it's not in self-defense. So if you could show the court that basically both people have committed domestic violence or abuse against the other, and it wasn't just committed in self-defense, then the court does have the ability to enter mutual protective orders against each other. But in every other way, you're just gonna handle that the same way. A lot of times, if mutual protective orders have been filed, the court will set one hearing to hear both. So in other words, this petitioner, petitioner A against party B, and then party B's protective order against petitioner A, they're gonna hear those both at the same time and hear the evidence for both of the decision. As we talked about before, report violations of the criminal portions of the protective order to law enforcement. And there's a new law that's been passed that you a respondent can get a protective order expunged 3 years, at least 3 years after it's been entered, if there were no violations. And that a lot of people want to do that because they don't want a protective order showing up on a background check. Any questions on this last section or comments?
Sign up for better. Okay, so this next section, we want to talk about some of the differences between giving legal information versus legal advice. Because which one are you guys allowed to give? Legal information, but not advice. And so thanks to Nathaniel Player and the Court Self-Help Center, they did kind of the basis for a lot of this presentation. And so when we're talking about the difference, it's hard to define what's the difference between legal information and legal advice. Does anyone want to throw out definition? Okay, but so it matters in the sense that only attorneys or someone licensed through the bar is supposed to be able to give legal advice. If you're giving legal advice outside of that, you could be reprimanded by the bar. And also you have certain rules of conduct as being a victim advocate. So we want to explain kind of what you can do by giving legal information. And this is another plug for our CAP program. So you could give legal advice. If you do that and get certified, then you can talk about protective orders and stalking injunctions. And so generally, we were trying to come up with a good way to define this too. We'll come to the next slide. This is just the statute of the unauthorized practice of law. So if you aren't admitted to the bar, if you've been disbarred or suspended, you're prohibited from practicing law by the court, you aren't supposed to do that. So just there's a statute, you know you aren't supposed to, and we'll talk about what legal information is. So we tried to break it down here. So legal information, it's general but relevant. So it can be helpful to you, it's informative, and you can get options and procedures. It can involve kind of translating what someone is saying and maybe plain English into some legal concepts and vice versa. And so if you said, talk to any lawyer and they're gonna say, this is what you would do, this is the process. So this is a lot more general for legal information. And usually you're using terms like, well, you could do this, one could apply for this. You aren't telling them you should do this, or in your specific case, this is what I would recommend. Legal advice is where you apply the law to a specific set of facts. It's very specific and it's directive, or it's trying to be predictive. Like, I think the court is going to rule in your favor. You have a really good case. Instead of saying legal information based on what you're saying, you want protection from your abuser. It sounds like you could apply for a protective order. There is that option. There are also other types of orders, maybe get some legal advice to determine what you need. So if you're starting to interpret statutes, cases, rules, that's legal advice. And if you talk to a lawyer, you might be getting different opinions when you're talking about case strategy or how they would do that. Usually you're getting into the realm of getting legal advice. This legal information is usually going to be pretty basic. It's going to say, this is the process. Here's that. This is, you aren't explaining the rules, but you might say, oh, there's a deadline. We need to file this. So anything that's more general, that's going to be considered legal advice. I think we're back to you, Tatiana.
Okay, so let's go through some examples. Legal information. How do I get divorced? This is an example of legal information. Well, you can hire a lawyer, require a legal, license for a legal professional, you could use OCAP and the court self-help materials to do it yourself. There's another example of legal information. Client says, I need to serve my spouse to start my divorce, but I only have their email or 20. Well, the rules require you to get a physical copy of the summons and petition. You can try to find them or ask the court for permission, special permission to serve them by email. Okay, here's examples of legal advice. I want custody of my kids. You should file for legal custody and use the following arguments. Yeah, from the next one. Here's another example of legal advice. Court denied my motion for ultimate service. You can file again. You should file again. This time, be sure to explain to the court that you asked your friends and your family to help. If you were unable to. So you can see that legal advice applies the client's specific facts to the law, or applies the law to the client's specific facts and their specific situation. Legal information is general information that could apply to anyone. So I think the fastest, most succinct way to tell the difference is, you know, if the thing that I'm about to say or just about to say makes sense if I tell it to literally anyone, or does it just only make sense to this client in this situation? Information and advice. I'm afraid of my husband and I want to get protection. You should file for a cohabitant abuse protective order. Is that information or advice? Advice. Yeah, that's right. What's an example of information for this person? Can someone come up with one? Could you give me an example of information, legal information for this person? You can explain all the options. That's exactly right. Well, there are several options in Utah or in the tribal court or someone in this situation. Let me tell you what they are. Information or advice. What will happen at my protective order hearing? Based on your request, there is a good chance the court will grant your request. Be sure to emphasize the threats of violence. Tell the commissioner about how he said he would hurt you. Is that information or advice? Advice, yeah, that's exactly right. It's advice because it's specific to this person's situation. And you are advising them, you're telling them what they should do in the hearing. What would be an example of information in this situation? Yes. Exactly. You can give them a general outline of the procedure, what happens in this type of case. As you said, give them a walkthrough of the process. This is how this usually goes. So you could say, you know, both parties are there. Each party will have a chance to explain their side of the story. The court will listen, will give you a chance to reply, and then the court will make a decision based on who you think is most credible. And whether they think abuse occurred. That's a good example of legal information. Here's another one. My abuser violated the protective order, calling me at 3 a.m. and leaving a voicemail about how sorry I am. If you want to enforce the order, you will need to contact the police. Is that information or advice? Information, I saw. Yes, that's right. Because this would apply to anyone in this situation. It would not be out of place or inaccurate to say, if anyone wants to enforce a protective order, they would need to contact the police. All right. Information or advice. I'm upset with what the commissioner is. This your turn now? Okay, I'll switch over.
So if you said, I'm upset with what the commissioner ordered at my hearing, is there anything I can do, or do I just live with it? You could say, if you think the commissioner wrote it correctly, that way you aren't getting any bias or saying what you think happened, you can file an objection to the commissioner's recommendation within 14 days. Would that be advice or information? Sorry, I'm hearing. Information. Yes, I would say more information, because you're saying, if you think the commissioner ruled incorrectly, you aren't saying, oh, I agree with you, that was wrong. So you aren't interpreting statutes. You're saying you can file this And so just letting them know what the options, you aren't telling them what they should or shouldn't do. And then they can also seek additional legal advice. And so how can I help answer these questions helpfully without giving advice? So we were trying to come up with different steps. So you can explain what legal process is, you can give options, and then kind of ask clarifying questions like, what are you wanting the court to do? What are you wanting to happen? Rather than just implying saying, oh, you must want X, Y, and Z in your case. You can ask the client, like, what are you trying to accomplish by filing this case? And then you can make referrals. We just put a couple down on here. The court has their OPAP website, the self-help center, and they will give you legal advice. They will not give you, they will give you legal information, not legal advice. There's Timpanogos Legal Center, Utah Legal Services, Legal Aid, our CAP advocates, the Crime Victims Legal Clinic. So there's all of these different places that can give a lot of really good advice in these areas and provide services to victims. Any questions on this part so far? Okay, let's go. We can keep cruising through some of this stuff. And let me know when we get to the next section. So kind of as we're practicing, we can go through some of these situations. So we can say, first, we'll explain processes, give options, ask those clarifying questions, and refer to resources. So say you have someone come into your office and they say, my creepy neighbor has been following me around the neighborhood. I want him to stop. If we were giving legal information, what would we do? Slow down. Maybe just start by explaining the process and say, sounds like you want him to stop. There are legal processes in place. You could maybe there are stopping injunctions, and maybe explain what that is and just explain the process of how you would file. You can give the different options and say, well, I don't know your situation, but there's options. There's protective orders, stopping injunctions, kind of going through the list, trying to keep it broad and not giving the specific advice. You can ask clarifying questions and say, well, what do you want to happen? What do you want him to do? And then hopefully you'll get some more information from the client to say, I want him to stay away from me. I want to have an order from the court. And then you can get some better direction. And then once you get to that point, you can say, it sounds like you might want some legal advice or some resources. Try the OPAP website. There are forms available on there. If you have specific legal questions, you can contact these partners and get the list of resources. Okay. I'm really struggling with this request for protective order form. What do I put to get the judge to rule in my favor? And so when you're talking about processes, you can maybe the information from the court's website, or maybe just read the statute. You don't have to interpret it, but to say the court needs to find domestic violence under this statute to qualify for a protective order. You can't say, I believe this is your domestic violence or this incident would fit. You can't be giving the specifics and applying it to the facts of their case, but you could just explain the process to say a protective order requires domestic violence and kind of give the different options. And then ask those clarifying questions of maybe, well, what happened? What occurred in your case? Describe what's happened over the relationship, and then you can kind of give those resources and say, well, if you need help with the protective order, you could call Utah Legal Services if you're somewhere else in the state, or Legal Aid Society if you're in Salt Lake County. Section 2. Okay, and back to 10.
Okay, and I think it's a good idea to mention that with this example, you might want to say, well, which part are you struggling with? I can try to explain the terms or the questions. If there's a specific part that you don't understand, I can tell you what they mean by that. That is legal information. Okay, my friend told me that if I apply for a protective order, that I can get my kids back from their dad. The court just gave him custody. Can you help me? Anybody want to take this one and try to role play and say what you would tell them, and just using legal information instead of advice? Anyone? Thank you. I give the mic to Ashley again. Ashley the brave. Oh, I would say that's a tough one, but it does happen a lot. Usually just an explanation of what a protective order is intended for, and then on the forms itself, at the very last portion before petitioner signing, actually says, I'm not using this to, harass the other party or as a, a workaround in any way, so kind of just explaining what protective orders are intended for and, telling them to seek legal advice. Great, thank you. Does anyone want to add to that? Good answer. I think it's important to use the forms themselves. To use the Utah Courts website, you can point out anything to them, any information that's publicly available on those forums or on the court website. I'd like they ask some clarifying questions too. I think with this person, if I were in a situation where I couldn't get legal advice, I could at least probably say, well, tell me a little bit more about that. What was the process that happened that caused the court to give you custody? And then they get more information there that helps you understand what the next step might be. Again, trying to avoid giving that legal advice, but you can at least understand more of the situation and where they're coming from. And then you might better be able to direct them to resources that will be able to help them. But I think it is very important, as Ashley mentioned, that protective order form does have that warning to petitioners that if they lie or are using the court process to harass the other person, they could be found guilty of a misdemeanor. Is it a misdemeanor or a felony? Yes. I'm over here to give the mic to our friend over here from legal aid.
So what I would probably say to this person is, I would start by saying that, addressing the protective orders are for your safety and not for addressing custody issues. But that if domestic violence has occurred and you do have grounds for protective order, you can address an emergency change in custody through the protective order. And then go over any changes that are made would be temporary, long-term changes need to be made through a modification of the divorce action and go over those things with them. Just to make sure that it's not specifically being used for custody, but also letting them know that if there is DV and they need a change in custody, that can be addressed.
That's excellent, thank you. I like her answer because everything that she said is legal information in the sense that it could apply to anyone. And you can say, any custody that's going to be awarded as part of a protective order is going to be temporary. That applies to everybody, so that's legal information, not legal advice. Here's somebody else.
So I will provide this by saying that I will provide this by saying that I am an attorney, but in the mind of an advocate, the first thing that I would do is ask clarified questions. I wouldn't just go forward and making that assumption that she's trying to use the protective order process to get back the kids. So for example, I would ask, what do you mean by the court just gave him custody? Just can mean last week, it can also mean 2 months ago, it can be 3 months ago, that's in the realm of time just. And I would also ask, why do you want to get them back from their dad? Because that could mean, instead of having the client or the potential client shut down, thinking that, well, you think that I'm abusing the system, the answer to that question might be the court awarding custody to him or to her 2 months ago or a month ago, and since then, my child has disclosed certain behaviors, or my child has disclosed sexual abuse or physical abuse, or my child might have a fear of that type of thing. Of course, there are other questions that the court might consider in terms of credibility and timing, but these are all valid reasons why a person might think, because the court has that they have no more options for help, and now there's new information and they don't know what to do. So we want to ask, I think the first thing I would do is ask some clarifying questions that would open up what are the available options, and then in explaining those options, describe the appropriateness and the warnings towards each option.
Yeah, all excellent points, thank you. Yeah, I think as an attorney, it's really easy to see everything as a legal issue, because if you have a hammer, everything looks like a nail, right? But if you, I think as advocates, it's really, really important to talk enough with our clients and ask those clarifying questions to make sure we understand what their goals are. And if there's any other ways to reach that goal that might be easier than going through a potentially traumatizing process. How much time do we have left? Okay, so I'm just gonna give this as an example. I think my husband's abusing our daughter. I need to get total custody of her. What do I do? Just think in your mind what you would say. We don't have enough time to go through this in another exercise probably, but this is something that you want to, if you're wanting to get legal information, you can explain the processes and give options. You can say, look, for one thing, I think asking a clarifying question is appropriate first. What makes you think he's abusing her? Not in the sense of, I don't believe you, you have to prove yourself, but in the sense of, help me understand what has happened that makes you think he's abusing her or causing abuse. And then once you understand what evidence there is or isn't, then you can go ahead and explain it. You can explain, well, Utah has a mandatory child abuse reporting law. You have credible information and you reasonably think that a child is being abused, you must report that to law enforcement or to DCFS. That again, that's legal information because you can say that sentence to literally anyone and it makes sense. You could also talk about the option of filing for a child. There is another option of filing for a child protective order. In order to file for a child protective order, you would need to report to DCFS first. Another option is to file for divorce and file a temporary injunction. To get a temporary injunction temporary, what is it called? Temporary orders, but if there's like a temporary restraining order that's the extreme, expedience kind that you get fast, you have to show that there's immediate and irreparable harm if that order doesn't pass. You have to have evidence that that's a heightened standard of evidence. But if you are able to do that, then to show that be prepared with your evidence for court, and the court may order immediately that the child is removed and that you would have temporary custody. So those are different options that a person has to go about getting custody or getting protection for that child who's being abused, potentially.
I guess what if you report it to the CFS and then the CFS determines that it's not considered a child abuse? At that point, what are your options?
Good question. So DCFS has their own processes and their own investigation. You can, once you've reported to DCFS, you can also, while they're doing their investigation, file for a child protective order or file for temporary order in the divorce case or custody case. So those judges in those different cases are going to look at the circumstances and they have a different standard of evidence that they're going to be working off of in DCFS. So it's possible for DCFS to close the investigation, but still for you to get, for example, a child protective order in the juvenile court or to get a restraining order in the divorce court, for example, because they have a different standard of proof that they're working with. And so they may find you credible that this child has been exposed to abuse or neglect, even if DCFS does not find that. But obviously, a finding by DCFS is gonna help the case if you're filing in another court too, so. We're pretty much done out of time, so if anybody has any last minute questions or comments, I can take those now. Okay.
All right, we have a pretty good question online. It says, if you know somebody wouldn't qualify for an order of protection under the law and they request our help with one, how do we legally explain why it's not appropriate without giving them legal advice?
That's a good question. So I would say, first of all, you can start by saying that there are a lot of different types of abuse, and we recognize that all abuse, whether it's emotional, psychological, spiritual, financial, physical, whatever, is important and very detrimental and should be taken seriously. And that Utah has chosen to only recognize physical and sexual abuse as the basis of a protective order. So with that knowledge in mind, there are certain kinds of abuse that are still very serious and should be taken seriously, but may not rise to the level of being able to get a protective order. Would you like to speak to an attorney about your chances of getting a protective order based on the abuse that you described to me? And then you can refer to an attorney for advice.
And we were talking about how this is a hard spot, especially as advocates, like we want to be there and tell our clients, yes, there are these options available, but sometimes they need to be told frank advice and kind of be given the expectation of court rather than spending all that time and effort in getting to court and being denied something which we could a couple weeks ago before the hearing was set. And so we were saying, we're happy to be the bad guys. If you guys need to refer clients to us to give them advice or give them not necessarily bad advice, but just realistic expectations of what might happen at the court. Because we don't want them getting exhausted and going through all of this when they're already dealing with so much stress. It's very hard to be told no multiple times. So it's much easier to be told no before filing the petition rather than being told no by the judge at the hearing.
We do really want, part of our mission at TLC is to be support to victim advocates. And that's one of my new roles as a TLC staff member is to be victim advocate support. And I want to be available and make myself available for any questions that you might have. And if you have any needs that we might not be aware of, please let us know. My personal email is Tatiana@timlegal.org, brooks@timlegal.org. And we also have a hotline. And we accept calls from advocates and other partner organizations on our hotline in addition to potential clients. So please do reach out if you have any questions or any feedback that you think we should have, or any suggestions for growth or anything that we can try to help with.
I was just gonna add one more thing. I left a couple of cards up here, so if you guys need our contact information, you've got that, feel free to reach out to either of us with any questions. We're happy to help answer them. Also, if you need any resources for your offices to get out to clients or to have at your display in the front, we are in the process of reprinting our brochures and our general hotline cards. So I don't unfortunately have them in person right now, but let us know and we are happy to mail you a stack or however many you need, just let us know because we want to make sure that we're getting all of our information to your clients and everyone that might need help. So hopefully in the next week, we should have those printed and then we can start mailing. Thanks, guys.
Okay, I'm not from this area, but I